Go ahead.
Your Honor, I have to recite something for the record. I've talked to Mr. Snedden about this and the clerk. In the transcript, at page 6335, there's a reference to playing a tape, exhibit number 813, and a further reference to the fact that that was the move from the house. There's all sorts of possibilities as to what could have happened here, but it turns out that 813, as it's marked by the clerk, is an exhibit that did not come into evidence and is something else, okay? As far as I can tell, it appears that 818 is in fact the exhibit previously referred to on the record as 813. So I think if we just recite it, we'll let the chips fall where they may.
The chips are someone misspoke and that's what happened, and thank you for correcting that.
Okay, so 818 does show it was received into evidence, and this does purport to be the video of the house, so whatever the record shows before, that's what we're going to play now, if that's all right.
That's all right.
All right, thank you. What I'm going to do, with the court's permission, is start it, just so the witness can see the very beginning, and then I'll fast forward, and I'll just use fast forward, because it's very shortly thereafter it shows the moving people, and then we'll go from there.
Okay, whereupon, a portion of a DVD, People's Exhibit 818, was played for the court and jury.
I'm going to pause here right at the beginning. There's a gentleman there who seems to be doing some cleaning or something. Does he appear to be one of your employees?
No.
All right, and we see a date of March the 5th, 2003, just for the record. Let me now play, and I'm going to go ahead and fast forward. Whereupon, a portion of a DVD, People's Exhibit 818, was played for the court and jury. On the counter, we're now at 3:32. I'm going to freeze this for a second. These gentlemen seem to have shirts that say, Dino's Moving and Storage. Are those your people?
Yes.
Do you know who they are from the back?
The foreground would be Joe Chavez, and the background is Carlos Solano.
And Mr. Chavez and Mr. Solano, have they been employed by you for some time?
Quite some time. A few years.
Are they trusted employees?
Very much.
Your Honor, unless somebody wants me to play more, that's all I want to play.
Well, we're not going to take a vote on it, so, laughter.
Very well. So I'm going to press stop and take the thing out, and I have no further questions.
Anything further?
No, Your Honor.
All right, thank you. You may step down. Now, the understanding was he can take his original records with him?
That's correct, Your Honor.
I also still don't have a copy of what was originally in my file.
That one sheet?
The in progress with the signature on it.
We can give you a copy of that right now, can't we?
Yes. To save time, I'll just give him my copy and I'll have another one made.
I have a copy of the other one, so I'll just give him mine and you can keep yours, and then we don't have a problem.
Just for the record, so we're clear, I am returning 818, in that envelope, to the clerk, along with the other exhibits.
All right, thank you. All right, call your next witness.
Theresa Marquez, please.
When you get to the witness stand, please remain standing. Face the clerk over here and raise your right hand.
I do. Please be seated and state and spell your name for the record. My name is Theresa Marquez. Theresa Marquez. Thank you.
May I proceed?
Yes.
Ms. Marquez, what is your current occupation?
Custodian of records at Kaiser Permanente in Baldwin Park, California.
At what location, please?
Baldwin Park, California.
Were you asked to make a determination as to whether or not there were medical records belonging to a Janet Arvizo?
Yes, we were.
With a date of August 28, 98? In other words, a visit to the ER room at a Kaiser facility on August 28, 98?
That's correct.
And in fact, were there records of that day?
Yes, there are.
And which Kaiser facility is that?
Baldwin Park Medical Center.
Where is the Baldwin Park Medical Center?
It's located in the city of Baldwin Park off the 10 freeway. You would get off on Baldwin Park Boulevard.
And that's in Los Angeles County?
Los Angeles County.
Did you make a copy of those records for us?
Yes, I did.
And do you have them with you?
Yes, I do.
Could we have those, please? Whereupon, an off-the-record discussion was held between Mr. Zonen and the witness at the witness stand. Off-the-record discussion held at counsel table. Could I approach the witness, Your Honor?
Yes.
I'm showing you now exhibit number 906. Is this in fact what you just handed me?
Yes, it is.
And are those in fact an accurate copy of the medical records from Kaiser Hospital?
Yes, they are.
For that date of August 28, 98, patient, Janet Arvizo?
Correct.
I would move to introduce those records into evidence.
They're admitted.
I'm sorry, Your Honor. I haven't quite had a chance to finish looking at them, if I could. We just received them.
If I could go on with just a different question, then.
I don't mind if he goes ahead while I'm looking at them.
Okay, go ahead.
Can you tell us the time? There's a registration time that's logged in these reports when a patient comes in. Is that correct?
That's correct.
What does the registration time reflect?
This reads 1:11 a.m.
1:11 in the morning, is that right?
Yes.
Alright, now, what does that mean, registration time?
That's actually the time they come to the desk and they ask to see a physician, and they are actually checked into the ER.
So that's the first time they actually meet with somebody at the hospital facility?
Correct.
Okay. Subject to the introduction of this exhibit into evidence, I have no further questions.
And I'll submit it as far as the admission of the documents.
All right, I'll admit the records.
I was doing too many things at once. What is the exhibit number, if I could ask, please?
906.
Thank you. Okay, so it appears that this person came to Kaiser Permanente on the 28th at 1:11 in the morning. Is that right?
That's the time that this member was checked in, yes.
Alright, so somebody, are you familiar with this particular facility?
Yes, I am.
So somebody they can walk into the emergency room, is that correct?
That's correct.
And they would be met by somebody who would assess their immediate need for medical assistance, is that correct?
Well, the procedure would be they would walk in. They would speak to the receptionist. Their medical record number would be taken. They would be asked a few questions. Then they'd be asked to be seated until a physician can come up to see them.
So when they walk in and have that first contact, that would be the time of registration, is that correct?
That's correct.
So this person walked in shortly before 1:11 in the morning of the 28th?
Yes.
And it appears, from the records, that the person was released that evening, right?
I believe that may be a misstatement, vague. Released that evening.
It was early in the morning, so however you want to put it. Early in the morning. It appears that the patient was released later that morning, is that correct?
Yes, it does.
About what time?
The latest time I see on here is 4:15 for the last note.
And it indicates at 4:15 in the morning, DC'd, right?
Yes.
That's discharged, is that correct?
That's correct.
Discharged in good condition, correct?
Yes.
And she was prescribed aspirin?
I don't know what she was prescribed. Not by this note. I believe the first page. We have a prescription of Motrin 400.
Okay, that was at 2:45 she was given some Motrin?
I am looking at the first page which indicates a prescription of Motrin. Let's see. It's indicating that at 2:45, she was given Motrin.
Alright, and then when people come in at that time of the early morning, is that a fairly busy time for the emergency room, usually?
That's difficult to say. We don't have trends of busy times and slow times.
Okay, I guess you can have a major problem, but that's one of the times when you're likely to see people coming into the emergency room, right?
You know, I really don't want to say that that's so, because in looking at the records, again, looking at trends, there isn't a definite trend as to if it's a peak time or not.
Okay, if there are other people there, then the person has to wait?
Correct.
And then they're eventually seen by a physician, is that correct?
Correct.
And then it appears here that she was seen somewhere around 1:45?
Well, if you look at the first page on the top, after time registered, triage time. That's when the nurse actually talked to her.
The triage time was what? 1:15?
1:15. And then they probably put her in a room until the physician can see her.
So in the ordinary course of things, she eventually had some x-rays, is that right?
That's correct.
And all of that came back negative?
Normal study.
And then it shows, 4:15, discharged in good condition.
Correct.
Alright, very good. No further questions.
No further questions. And the exhibit is in, is that correct?
The exhibit is admitted.
Thank you.
Thank you. You may step down.
We'll call William Dickerman to the stand.
He's recalled. Is that correct?
Yes. Recall him. Thank you. Who's doing Mr. Dickerman? Oh, okay. Off the record discussion held at counsel table.
Come to the front of the courtroom. You were previously sworn. You may be seated.
May I proceed, Your Honor?
Yes.
May I approach the witness?
Yes.
Mr. Dickerman, good afternoon. And we are just at good afternoon.
Good afternoon. Microphones off.
Thank you. If the trial goes another 4 months, I will learn. Thank you for coming back. We have a few questions to ask you about a few exhibits. You brought with you a collection of letters and communications, is that correct?
Yes, I did.
And I'd like to show you right now a collection of documents that's before you that is now marked as People's Exhibit number 903, is that correct?
Yes.
And could you take a look at those very rapidly, just to assure yourself that those are the same documents or a copy of documents that you brought with you today, is that right?
Yes.
And those are copies of documents that you have in your file?
Yes.
And that file you brought with you today, is that right?
Yes, I did.
So to the extent that you have actual copies, the actual copies you brought with you, and these are copies of copies?
I've also got originals that were faxed.
And originals that were faxed, is that right?
Yes.
Now, do these represent communications between you and an attorney by the name of Mark Geragos?
They sure do.
You testified previously to some communications, and some of those letters were shown to you previously, is that right?
Yes.
Alright, but I'd like to specifically go over some of these letters and talk to you about how they were communicated specifically to Mr. Geragos, is that alright?
Sure.
Let's begin with the very first letter on this collection of documents that is marked 903. And this letter is dated March 26, 2003. Is this a letter that you authored?
Yes, it is.
Is this a letter that you sent to Mr. Dickerman, excuse me, Mr. Geragos?
I had it messengered to Mr. Geragos.
Alright, and explain what you mean by having had a messenger deliver it.
I or my secretary phoned All-Star Messenger Service, which is the attorney service, messenger service I've been using for about 15 years, put in an order, filled out a form, had them come over, told them to deliver it to Mr. Geragos, and they took it.
Alright, in this particular letter dated March 26, 2003, do you refer to the passports and visas belonging to your clients, the Arvizos?
Yes, in paragraph 2 at the bottom of the first page.
And the delivery service that you use and have been using for 15 years, is it your experience that they are reliable and responsible in delivering letters?
I don't think I've had a problem with them in delivering anything in 15 years, whether it's court documents or letters or anything else.
Let's please go to the next document on here, and that's the one. It's about 4 pages in. It begins with, All-Star Messenger is the heading on the top. That, plus the next page after that, what are those 2 documents?
The first document is my copy of the form that was filled out and given to the messenger service, along with the letter to be sent. So there are, I believe, 3 pages of it. The first one they take, and the last one is a pink copy. I have the original here, and that is what I kept for my files.
And that also is dated March 26, 03?
Yes.
The second page is what, please?
The second page is the invoice from All-Star Messenger Service for that delivery, reflecting that I owe them $14.75 for delivering the letter to Geragos and Geragos.
Alright, move to the next page, if you would, please. Is this a letter to Mr. Geragos as well?
Yes.
And is the date on this April 3, 2003?
Yes.
Alright. In this letter, do you reference a prior letter that you sent him?
Yes. I referenced the March 26th letter that I just testified about.
And how is this letter, the April 3 letter, delivered to Mr. Geragos?
That was by fax. On my fax machine to his fax machine.
Alright. Now, if you'll turn to the next page, the page right after the April 3, 2003 letter, is that a facsimile transaction report?
Yes, it is.
Explain what that is, please.
Every time a fax is sent from my office, I get a report showing that the fax was received or it wasn't received, and the reason if it wasn't received.
Alright. Is this generated by your fax machine?
Yes, it is. It's a machine that I no longer have, but I had it for 10, 12 years.
Alright. Was it your experience that when this machine tells you a fax has been transmitted, that it actually had been?
Always.
Did you ever have an occasion where the machine told you the facsimile had been transmitted and in fact it hadn't?
Never.
Does this piece of paper now, and we're dealing with the one that says April 3 at 6:16 p.m., does this indicate that the fax that you had sent to Mr. Geragos on the 3rd of April in fact had been transmitted?
Yes.
And at what time of the day was that?
It says 6:16. The fax machine always ran a couple minutes off, so it could have been 6:14 or 6:12, something like that.
Go to the next page, please. Is the next page a cover letter from Geragos and Geragos, a fax cover sheet?
Yes, it is.
Does that contain Mr. Geragos's fax number?
Yes, it does.
Alright. Is that in fact the same fax number that you sent the prior communication to?
Yes. It says that right on the transaction report.
Alright. And in fact, all of your communications sent to Mr. Geragos were sent to that same fax number. Is that correct?
Yes, that's correct.
Let's move to the next page. Is the next page a letter from Mr. Geragos dated April 6, 2003?
Yes, it is.
Alright. Now, that's 2 sentences, is it not?
Yes.
Would you read it out loud to us?
Dear Mr. Dickerman. Thanks for your letter of April 3, 2003.
Objection. Hearsay. The letter. The document speaks for itself.
It is speaking for itself. He's just reading it.
Okay.
That's how it talks. Laughter. Go ahead, counsel.
Go ahead and please read it.
Thanks for your letter of April 3, 2003. Please give me a call so that we can make arrangements.
Now, in your experience as an attorney, when you get a letter back from somebody else who thanks you for a letter dated a particular date, that tends to suggest that they got that letter. Is that right?
In my experience, always.
Alright. Now, going back to your letter of April 3, 2003, let's turn back a few pages. The letter that he acknowledges that you received.
Oh, sorry.
Do you have it in front of you?
Yes.
The letter of April 3, 2003, that he acknowledges that you received. What, in the first sentence, what do you say in that letter?
Dear Mr. Geragos, on March 26, 2003, I wrote you and asked that you deliver certain items to my office by April 1st.
You don't have to go any further than that. That letter that he acknowledged receiving referred to the March 26, 2003 letter, the one that demanded the passports and the visas. Is that correct?
It's the only letter I wrote on March 26th.
Alright. Now, let's move on. We left off with Mr. Geragos's letter to you that's dated April 6, 2003. Go to the next page, please. Is that next page a letter from you to Mr. Geragos dated April 8, 2003?
Yes.
Do you refer to passports, visas and birth certificates in that letter?
Yes. In the 3rd paragraph.
Alright. How is this letter communicated to Mr. Geragos?
By fax machine to the same number as the others that I had faxed.
And did you in fact keep a transaction report from your fax machine indicating whether it had been successfully faxed?
Yes. That's the next document.
And that's the next page. Is that correct?
Yes.
That transaction report indicates what?
That on April 8 at 7:18 p.m., I faxed 2 pages to Mr. Geragos's fax number, and that it was received.
Okay. Let's move on, please, to the next page. The next page is a letter from you dated April 9, 2003. Is that correct?
Yes.
This is also a letter to Mark Geragos, is that correct?
Yes.
Okay. Was this letter faxed to him?
Yes.
Was that letter received by him, or at least was it? Did your fax machine indicate that it went through?
Yes.
Alright. In that letter of April 9, 2003, do you reference passports, visas and birth certificates?
Yes.
Actually, you demand their return to your client, is that correct?
Yes. I asked that he, quote, immediately deliver to me, along with the documents you just mentioned, some other items.
Now, the next page again, as we acknowledge, was the transaction report on the fax machine?
Yes.
Please now go to April 11, 2003. Is that the next page?
Yes.
Is that a letter from you to Mr. Geragos?
Yes.
Was that faxed to him as well?
Yes. At the same number.
And the transaction report indicates that that letter was processed as well?
Yes.
Please move to the next one. We now have a letter from Mr. Geragos to you, April 15, 2003. Is that correct?
Yes.
Okay. And that is a letter from Mr. Geragos that appears to be one sentence?
Yes.
Alright. What does that sentence read?
We have retrieved various items from storage and would appreciate your advising us as to where they should be delivered.
Did Mr. Geragos up to this point, either by telephone or in any other communication, indicate to you anything about passports belonging to your clients, the Arvizos?
He, in one conversation, I think it was on March 31st, I asked him about passports and visas, following up on the letter that, well, when he called me, because he wanted additional time to respond to the March 26th letter, we talked about it briefly. He didn't exactly know what I was talking about. I think he said that there were passports around that he had heard of, but he didn't know what it was, what that was about.
Okay.
I understood he was going to find out and get back to me. He never did.
Did he ever?
He never got back to me on that. He never responded to any of my letters asking for any of these items, except for items in the storage unit.
Okay. Moving on to the next page, a letter dated April 22, 2003.
Yes.
Is that a letter that you sent to Mark Geragos?
Yes.
And this letter is dated April 22, 2003. Do you once again demand the return of their possessions, including their passports?
Yes.
Was this letter delivered in some fashion to Geragos and Geragos?
It was faxed at about 2:17 p.m. to the same fax number as I previously stated, and it indicates that it was received.
Okay. Move on to the next page. A letter dated May 12, 2003, from you to Mr. Geragos. Is that correct?
Yes.
Alright. In this letter, do you fax this letter to him?
Yes.
And did your fax report, the next page in these documents, indicate that it was received?
Same as all the others, yes.
Next letter, please, the next page. Is this a letter from Geragos and Geragos, from Mark Geragos to you?
Yes.
And the date is May 15, 2003, is that correct?
Yes.
Alright. In this letter, does he acknowledge receipt of a prior letter from you?
Yes, my letter dated May 12th.
Does he refer to passports at all?
No.
Move to the next one, please. May 15, 2003. Is this a letter from you to Mr. Geragos?
Yes.
And in this letter, do you once again ask him to return immediately your client's passports and birth certificates?
Yes. And the last sentence of the second paragraph, and you can see my frustration, because I underlined immediately, and I had been getting no response, so I was quite disturbed.
Objection. Move to strike.
All strike the after yes.
But the word immediately is, in fact, underlined. Is that correct?
Yes.
Alright. Now, did you send this by facsimile?
Yes.
And do you have a transaction report that indicates it was, in fact, processed?
Yes.
Alright. Can you tell us when this letter was processed?
It says 4:33 p.m., May 15th, to the same fax number.
I'm sorry?
To the same fax number.
Okay. The next page is a fax cover sheet from Mr. Geragos, is that correct?
Yes.
And the next page after that is a letter from Mr. Geragos back to you?
Yes.
Now, the letter is dated, from Mr. Geragos to you, May 17, 2003, is that correct?
Yes.
Please read to us the first sentence of that letter.
Thank you for your histrionic letter dated May 15, 2003.
Are communications getting a little testy at this point?
Yes.
Okay. But he acknowledges receiving the May 15, 2003 letter?
Yes.
And the May 15, 2003 letter specifically demands the immediate return of your client's passports and birth certificates. Is that true?
Yes.
Let's move on to the next, a letter from you dated May 20, 2003. You sent that to Mr. Geragos?
Yes, by fax.
By fax. Again, the same fax number?
Identical.
All of these are to the same identical fax number?
Yes.
And you, once again, have a transaction report indicating that that letter was properly processed.
Yes.
May 29, 2003, another letter from you to Mr. Dick, from you to Mr. Geragos, is that correct?
Yes.
Properly faxed that same day, May 29. The next page is a letter from Mr. The cover sheet of a fax from Mr. Geragos to you, is that correct?
Yes.
And then the next page after that is a letter from Mr. Geragos to you dated June 2, 2003?
Yes.
Alright, it references your letter of May 29, 2003, is that correct?
In the first sentence.
Alright, does not mention anything about passports, does it?
No.
And finally, the last page of that is a document that appears to be a fax to you from Bradley Miller, is that correct?
Yes.
And that's dated June 12, 2003, is that correct?
Yes.
Up until this facsimile was sent to you by Brad Miller, did they ever tell you where your client's possessions were?
No.
Did Mr. Geragos or anybody from his office ever acknowledge the fact that there were passports that belonged to your client and were in his possession?
No.
No further questions. I will move to admit, excuse me. One more second. Mr. Dickerman, the documents, the copies that you have before you that are the collection, a complete. Let me do that one more time. Exhibit 809, 803.
903.
903. It's Friday, isn't it? Thursday. I'll start again. Exhibit number 903, a collection of documents that are, in fact, communications between you and Mark Geragos. Is this a complete collection of the letters that were sent by you to Mr. Geragos and returned from Mr. Geragos to you?
As far as I know, yes.
And this is an accurate copy of each of these documents, is that right?
Yes.
I would move to introduce into evidence exhibit number 903.
No objection.
It's admitted.
Mr. Dickerman, I'd like to refer you to your letter which purports to be dated March 26, 2003. Do you see that?
Yes.
Is that letter signed?
This document does not bear a signature.
Do you have a copy of a signed letter of March 26?
No.
Do you normally sign letters that you send as a lawyer?
Always.
Why didn't you sign this one?
I did sign the letter. This is a copy.
Does anyone know where it is, a copy of the signed letter?
Apparently I didn't sign. I didn't copy the signed letter. I probably ran a duplicate from the printer. And I usually do not copy my signature because it's easier to run a copy from the printer than to go to the Xerox machine.
Let's look at your letter of April 3, 2003. Does that have a signature of you?
It does, because that was a document that was faxed. That's the exact copy of what was faxed.
You're suggesting that when you messenger copies of your letters you don't sign them, but when you fax copies of your letters you do sign them.
No.
What are you suggesting?
A document that is faxed is the exact document with the signature. I have an original of a letter that I mail or messenger, and the original would be signed, and very often I don't copy the signature, but I run a second copy out of the printer.
Have you been in touch with the prosecutor about these letters before you testified today?
Yes.
Did he ask you to look in your file to get copies of your letters?
I'm not sure, but I told him I had copies of my letters.
Did he ask you to look in your file and look at the copies of the letters you claim you sent to Mark Geragos?
I don't remember specifically.
So far, there is no copy you've been able to find of a March 26 letter that you actually signed, true?
Yes.
Yet, we have other letters in this package that you did sign, right?
That's right. And as I explained, They are copies of precisely the document that I faxed. I would not fax a document without my signature. However, I did messenger the document with my signature.
How do you know that if you don't have a copy of the signed letter?
Because I sign my letters before they go out.
Where is the copy?
I didn't make a copy of my signature. There's no reason to make a copy of my signature. These copies are of faxes that were sent that were faxed. They are faxed, obviously, with my signature.
When you make a demand letter like the letter of March 26 on behalf of a client, do you routinely sign the letter?
Always.
Where is the signed copy?
That's argumentative.
Sustained.
You don't have a signed copy, do you?
Objection. Asked and answered.
Sustained.
Let me refer you to the first page of your March 26, 2003, letter. I'd like to refer you to the last paragraph. It's number 2. Do you see that?
I do.
You say as follows. The Arvizos demand that Jackson immediately return to them, and I want you to look at item B, the papers they have signed, including passport, visa applications, school documents, documents in connection with the legal action in Britain concerning living with Michael Jackson. Do you see those words?
I do.
Isn't it true that later, after you sent this letter, assuming you sent it, your client, Janet Arvizo, denied ever authorizing a legal action in Great Britain?
I'm going to object as compound and vague and exceeding the scope of the direct examination.
Microphones off.
He introduced it into evidence, Your Honor.
This letter's been in evidence.
Sustained. Exceeds the scope of direct.
Okay. Let me go to the next page, number 4.
Yes.
You asked for copies of any model release your client, Janet Arvizo, signed involving footage, right?
Can you point me to the line?
Sure. Paragraph number 4. 1, 2, 3, 4, 5. I'd say at 5, 6, lines 5, 6 and 7 in paragraph number 4.
Where it says, titled, this model release.
Yes.
Okay.
Now, did you have a copy of a model release when you wrote the letter?
I don't remember.
Did Janet Arvizo tell you she had negotiated and signed a model release?
Objection. Exceeds the scope of the direct examination.
Sustained.
Let's go to the letter you claim you sent to Mr. Geragos on April 8, 2003. Do you see that?
Okay.
Let's look at the first paragraph. 1, 2, 3, well, the first complete sentence. Excuse me, I'm sorry. The second complete sentence. Could you please read that sentence to yourself?
Okay.
You say in your letter to Mr. Geragos, referring to the apartment, she tells me that, contrary to what you said about there being a truckload, she had very few possessions, since she lived in a bachelor apartment. She does not believe that much, if any, furniture was removed. Was that what Janet Arvizo told you about her address at Soto Street?
Objection. Exceeds the scope of the direct examination.
Sustained.
In that paragraph, are you referring to the Soto Street address in East Los Angeles?
Objection. Exceeds the scope of the direct examination.
Sustained.
Let me refer you to a letter of April 11, 2003, that purports to be to Mr. Geragos from you. Do you see that letter?
Yes.
And in the second letter, you write, my clients have also learned that Mr. Jackson has produced or is producing and that Fox will broadcast a program involving home videos or home movies. Do you see that?
Yes.
Did your client tell you that?
Objection. Exceeds the scope of the direct examination.
Sustained.
Let's move to a letter from Mr. Geragos to you, which is signed and faxed on April 15, 2003. Do you see that?
Yes.
Mr. Geragos says to you, we have retrieved various items from storage and would appreciate your advising us as to where they should be delivered, right?
Yes.
And did you immediately advise him where to deliver the items?
No.
Why not?
Well, if you go back to previous letters, and I don't know which exactly they are without going through and reading them, I had requested, on numerous occasions, I believe, that Mr. Geragos give us a list of what there was, and to tell us where it was. And I had told him that what we were most interested in were passports, visas, birth certificates and these other things that are included in the March 26th letter that apparently he says he didn't receive, but that he acknowledges having received in phone conversation and refers to in subsequent letters. It was obvious to me that he was skirting the issue and trying to make the issue different from what it was, which was to get back these items. And we were not talking about the items in storage. We were talking really about the passports, visas, items of clothing that apparently were taken at Neverland, and the other documents and tapes and whatnot that was mentioned very specifically in the March 26th letter.
Let me ask you the question again. You may not have understood. Mr. Geragos, on April 15th, says to you, "We have retrieved various items in storage and would appreciate your advising us as to where they should be delivered." My question is, why didn't you tell him where to deliver them?
I'm just referring to these letters, because I know there is voluminous correspondence here about this specific issue. Well, if you look at the April 22nd letter, you'll see I wrote, quote, "Your April 15th, yes, I had asked for these items to be delivered immediately. There was no reason for there to be any discussion, any movement, any mailing, anything to get back the passports, visas, birth certificates and those other materials. Mr. Geragos never referred to those, except in this one conversation that I referred to. He never responded in these letters, and it was clear he was dodging the issue. And I kept on writing to him saying, these are the things that we want, and I didn't want him skirting the issue by dealing with things that were not at issue. And I wrote in that letter on April 22nd, quote, your April 15th letter. That's the one you just referred to, ignores the specific requests and refers simply to, quote, various items, period, close quote. As to those referred to above, you already have my instructions for delivery. I demand, for the fourth time, that you comply with my request, period, close quote. And then the second paragraph, here's the more specific answer to your question, quote, as for any other items, and that's referring to, I guess, the items that he was referring to in the April 15th letter, I repeat my request of March 26th that, quote, Jackson immediately provide a list of all, bracket, my client's, closed bracket, personal property that he possesses or controls or stored, whether it was left at Neverland, removed from my client's apartment, or obtained in any other way. They also demand to know the precise location of all such property, and the identity, address and phone number of each person with access and or a key to any place where the property is located. And that's a close quote, because I'm quoting the March 26th letter. And I continue, in order to know what to do with items other than those I have asked you repeatedly to deliver to me, and there I'm referring to the passports, visas, birth certificates and items of clothing, my clients need to know what and where it is. They have a right to know, too, period, close quote. And then I go on to discuss something else.
I understand.
Did that answer your question?
No, it doesn't. I understand all the legalese in your letters. What I'm asking you is, where do you tell them where to deliver the material? Show me some place.
I didn't tell them where to deliver the materials.
So he asked you where to deliver it, and you would not respond?
I believe the witness was interrupted.
It's asked and answered.
Did your client tell you that no furniture was stored on her behalf? And I'm referring to Janet Arvizo.
I don't remember specifically, but if it's in the letter, then that's what happened.
Well, in your letter of May 12th, you still haven't told them where to deliver it, right?
As of May 12th, he still hadn't told us what there was, where it was stored and who had stored it. I asked him very specific questions since March 26th. I asked him for a list of what there was, who had possession of it, where it was. They had a right to know those things. And his intention to just dump whatever he felt like dumping was not what we were about. It was quite easy for him to tell us where the stuff was. That's what I wanted to know. My client wanted to go out there and retrieve the items, not to have them delivered, actually, anywhere. What I wanted delivered and what I told him repeatedly, over and over and over again, was deliver the passports, birth certificate, visas, clothing, to my office. Yes, he knew exactly where to send those materials.
And when you didn't respond to his letter of April 15th asking you where he should deliver the possessions, you knew exactly what you were doing, didn't you?
Objection. Argumentative.
Sustained.
You and your client were trying to set up Mr. Jackson for a lawsuit, true?
Objection. Argumentative.
Sustained.
Did you have your profit-sharing arrangement with Larry Feldman at this time?
Objection. Argumentative.
Beyond the scope.
Could I respond to that?
No, it's beyond the scope. Next question.
Your Honor, could I correct a statement that I made in previous testimony? Because it seems to make a big difference here to Mr. Mesereau.
Your Honor, I think, with all due respect to the witness.
Next question.
Okay, all right. Now, I'd like to refer you to Mr. Geragos's letter to you of May 15, 2003. Do you have that in front of you?
May 15th?
Yes. 2003.
Got it.
And I'm referring you to. Excuse me, let me start off. Let me withdraw the question. First, Mr. Geragos indicates that your landlord refused delivery of items, correct?
Yes.
And it is true that your landlord did refuse to accept items Mr. Geragos had arranged to deliver to your office, correct?
Mr. Geragos had not arranged to deliver anything to me at any time, any place. The landlord, well, I don't know, landlord's representative, the person that I deal with at the property, left me a phone message about some things being attempted to be dropped off. I got that at home, as I was observing, or at the end of observing a religious holiday, which Mr. Geragos full well knew I was doing, because it was on my answering machine, and told me that these items were attempted to be delivered. And I came back to the office the next day, saw an email, I believe, I forget who it was between, and I wrote an email back to the office manager named Salome Ahadi and told her, she was expressing some pique about this having happened because no arrangements were made. And I said to her, and I'm almost quoting, I would apologize if I had any idea what this was about. And I said, I knew nothing about it, made no arrangements, made no agreement, have no knowledge about it whatsoever.
Let me refer to your letter of May 12, 2003, to Mr. Geragos.
Yes.
Don't you confirm in the first paragraph that Mr. Geragos sent movers to your office with furniture?
Yes, according to what the office manager had told me. I don't know for sure whether there was furniture or what was involved.
You didn't know for sure?
I wasn't there. As I say, I got this phone message.
Right.
And that's it.
Don't you write the following, Mr. Dickerman. This then will serve to confirm that on April 24 at about 9:30 a.m., you sent purported movers to my office laden with a huge amount of furniture and possibly other items that the movers told the receptionist and building services representatives I had directed and arranged to be delivered. You confirm that an attempted delivery was made of items and furniture, correct?
It wasn't from my personal knowledge, but that's what it says. That's based on what I was told at the office. I have no reason to believe that that's not correct. And I go on, if you want to keep this in context.
Sir,
To state that there was no such
I'll ask the questions.
arrangement.
I'll ask the questions.
Well, if you want to get to the truth here, Mr. Mesereau, instead of playing games,
Mr. Dickerman.
I'll be happy to explain all of this, and then we can have a reasonable trial where the facts come out instead of implications.
Just a minute, counsel. You're not an advocate here. You're a witness.
Sorry, Your Honor.
Everyone understands what position Mr. Mesereau is in and what position you're in. Now, I want you to listen to the questions and answer the questions.
I will, Your Honor.
Mr. Dickerman, when you wrote these letters on behalf of Janet Arvizo, did you think it was her right to decide what materials would stay in storage, paid by someone else, and what materials you would accept when you felt like accepting them?
Objection. Argumentative and compound.
You may answer the question. Do you want it read back?
No, but I'm not willing to waive the attorney work product privilege. He's asking for my thoughts, and those are out of bounds, as he well knows.
I think you need to listen to the question. Have the question read back.
Mr. Dickerman, when you wrote these letters on behalf of Janet Arvizo, did you think it was her right to decide what materials would stay in storage, paid by someone else, and what materials you would accept when you felt like accepting them?
He's asking for my thoughts. My thoughts are my work product. I'm not willing to waive the privilege.
The work product privilege doesn't apply in criminal cases. I know you're a civil attorney, so I'll give you a little leeway here.
I am. All right, I'm sorry. Could you read it back one more time?
What I'm going to do, though, is ask you to rephrase it so that I know the question you're attempting to ask.
Yes. Mr. Dickerman, in one of your earlier letters to Mr. Geragos, you confirm your belief that although there may be little furniture stored for Janet Arvizo, there in fact may be some, correct?
You'd have to point me to the letter.
Sure.
I don't have the letters memorized.
Okay, let me refer you to your letter of April 8, 2003.
Okay.
In that first paragraph, referring to your client, Janet Arvizo, you say that she does not believe that much, if any, furniture was removed.
Right.
Do you see that?
Yes.
Now, did she tell you she did not believe that much, if any, furniture was removed?
She must have, or I wouldn't have put it in the letter.
Did you ever confirm whether or not any furniture was removed from the Soto Street apartment?
I'm not sure what the Soto Street apartment is, so I guess the answer would be no.
Wasn't that the apartment that Janet purported to live in?
I don't know about the address. I don't know the street name.
Well, what apartment are you referring to in your letter?
An apartment that they lived in. I don't know that she ever referred to the address.
And Janet Arvizo never told you where the materials were taken from.
She told me they were taken from her apartment, but I don't know that there was any reason to tell me an address, a street number, or a street name. Or maybe she did and I just don't recall it. The name of the street was not important.
Was the purported home of Janet Arvizo, where materials were taken, allegedly, against her will, important to you?
I'm going to object as argumentative and irrelevant.
Sustained.
Are you saying under oath you didn't know what the address was of the apartment where possessions were supposedly taken from?
I may have known then. I don't remember now. The name is not familiar to me.
Did you review your file before you agreed to testify today for the prosecution?
I didn't review my file. I made copies of the documents that have been put in evidence.
How many meetings have you had with any representative of the prosecution before testifying today?
I don't know what you mean by meeting. I was upstairs in the room awaiting testimony, and Mr. Zonen came up and I gave him these documents. If that's a meeting, I don't know. One today and one before the last time I testified. And I testified to Mr. Snedden, meeting Mr. Snedden, gosh, I don't know, 2 years ago, or a year and a half ago.
I'll object as to irrelevant, anything beyond the prior testimony, and asked and answered.
Overruled. You interrupted the witness. I'm not sure you had completed your answer.
Yeah, I don't know what you mean by a meeting. A meeting can be defined as two people in the same room together. I never had a meeting for the purpose of discussing testimony or reviewing documents.
You don't know how to define the word meeting.
As I said, a meet. You define it and I'll tell you whether I had them. As I said, I was with Mr. Zonen for a couple of minutes upstairs. If that's a meeting, then, yes, I had a meeting with Mr. Zonen today. And I had a meeting with him the time before I testified last time. And I met with Mr. Snedden long before there was a case, I guess. But a long, long time ago. Just an introductory meeting, you know. I think that's it.
Well, Mr. Dickerman, in this series of correspondence with Mr. Geragos, you were threatening to sue Mr. Jackson on behalf of the Arvizos for a number of things, including withholding possessions from Ms. Arvizo that were taken from an apartment, correct?
You'd have to point me to that.
Well,
I don't know that I ever threatened to sue Mr. Jackson on behalf of the Arvizos for anything.
let's go to your first letter, then, on the 26th. Do you see that letter, the one that you didn't sign?
I signed it.
Okay, you just don't have a copy. The one you claim you signed, but there is no copy, correct?
Correct.
Okay, let's look at the last paragraph. It says, the Arvizos expect Jackson to comply with the demand to cease contacting and intimidating them immediately. His failure to heed this demand will force my clients to seek a civil restraining order and perhaps to vindicate their rights in other ways.
Yes.
You're not threatening a lawsuit?
Well, when you say a lawsuit, I think of actually a full-blown civil action. To get a restraining order is, I guess technically it's a lawsuit, but it's a quick thing. You go down to court, you put in a declaration, perhaps have some testimony, and it's done really quickly.
But, sir, it says, they may seek a civil restraining order and perhaps to vindicate their rights in other legal ways, right?
That's correct, and it's purposefully vague there. I didn't threaten a lawsuit. Other legal ways, meaning anything that we can legally do is a possibility, sure.
Like what, for example?
Well,
That isn't a lawsuit?
there's a writ of possession. You can't do anything without actually filing a complaint or a petition. In order to get a court order, as you well know, having practiced civil law yourself, you need to file some kind of an action. You can call that a lawsuit. You can call it an action. You can call it, I believe the civil procedure refers to a number. I think the Code of Civil Procedure refers to a number of different kinds of action. So as I say, when I refer to a lawsuit, when I ask somebody, do you want to file suit? I'm talking about a full-blown civil action with causes of action that you eventually go to trial on to recover, usually, damages for your client. Saying various other legal ways could have been, as I say, a writ of possession, which is, yes, you have to file some kind of a complaint or a petition, or whatever else there was. There was no decision made here as to what was going to be done, so to say, other legal ways, leaves open anything that my clients decided to do.
Including lawsuits, true?
Sure.
That's your first letter, right?
My first letter to Geragos.
Yes.
Yeah.
Was that the first letter you ever wrote to anyone on behalf of Janet Arvizo?
I think so.
I will object as exceeding the scope of the direct.
Overruled. The answer is in.
Now, when you first met your client, Janet Arvizo, you didn't ask about the address of the apartment that she was complaining about?
Objection. Asked and answered.
Sustained.
Now, let me refer you to a letter from Mark Geragos to you of May 15, 2003. Do you see that letter?
Yes.
Mr. Geragos writes the following to you. Since it appears that you are not equipped nor willing to receive the property at your office, we suggest that a simple matter in which to resolve this situation is for your client to assume the $100 a month charge for the rental units in which the property is being stored. Do you see that?
Yes.
Did you agree to that in your next letter?
You're referring to the May 15th letter in which I say, quote, "You seem to believe that if you repeat or imply a falsehood often enough it will be believed." Is that?
That's correct. Did you think it was false that he said the unit cost $100 a month?
No. What I was referring to was his statement that we had somehow agreed, or that he was acting properly in having these materials deposited, or he tried to deposit them at my office, when there was no arrangement, when he knew that I was out for a religious holiday, and we had no agreement whatsoever, and he had never responded to any of the requests to know what there was, where it was, who had possession of it.
Now, the day you learned that Mr. Geragos had a mover appear at your office, did you call him back and say, "I'm back in the office. Let's arrange to deliver it at a certain location"?
No. What I did was carry on correspondence with Mr. Geragos. I believe at one point, and I think there's a letter here, that when it turned out that he was being totally deceitful and dodging and not responding, I believe I told him that we should have no further communications orally, but that everything should be in writing. The reason these things are in writing, which I just never had an experience with anybody where there's this series of letters to get an answer to a question. The reason for this writing is just to document the impossibility of getting him to do what I had asked him to do so many times, which was a simple request. Give us the passports, the visas, the birth certificates. In fact, the other materials were not that critical. What my clients wanted were the passports, birth certificates, visas, the other documents that were very specific.
Did your client prefer that someone else continue to store the furniture at their own expense?
Objection. Asked and answered and argumentative.
Sustained.
In any of these letters, do you tell Mr. Geragos where to deliver the furniture?
Counsel. That's asked and answered.
Okay. Let me refer you again to the paragraph on the Geragos letter to you of May 15, 2003. He asked you on that date.
I'm sorry, what date?
I'm sorry, May 15, 2003.
Okay.
Mr. Geragos says, since we have not been able to resolve this, he asks if your client will assume the $100 a month charge for the rental units, right?
Yes.
And what was your response to that?
Well, that same day I responded to him detailing his lie about having had an arrangement to drop off those materials. And then I said, in the next paragraph, quote, "I will consider your suggested resolution once you comply with my previous requests that you provide a list of all items you intend to, quote, deliver, period, close quote. I was told there was a massive amount of furniture in your, quote, delivery, close quote, while my clients, who lived in a bachelor apartment, had very few possessions and little, if any, furniture. Your client, thorough deception, makes mine understandably reluctant to take his or your word for anything. I'd also like you to deliver immediately, underlined, my client's passports, birth certificates, and the clothing items previously described. And there, in the final paragraph, is my request that he not communicate with me in any way but writing, because I did not want any more, I hate to say this about another lawyer. I did not want any more lies. And if they were in writing, I didn't think that he was going to lie, although he continued to do so."
I understand. Let me re-ask my question again. In your response to Mr. Geragos, Mr. Dickerman, do you ever tell him, 1. where to deliver the items, are 2, that your client will assume the cost of representing the unit. Anywhere in all your verbiage, do you say anything about either of those issues?
Yeah, I said once he complies with my previous requests. I don't know if there's a problem. Is the microphone on? Maybe you're not hearing me. It says, well, now it's not. Oop, is it on now? It says that once he complies with my previous requests made over a period of, let's see, March, April, May, almost 2 months, that I would be happy to do what he wanted. Again, my client's immediate concern was not to get the items back from the vault. That was not the big deal.
And does your client care about who paid to store them?
My client agreed subsequently to pick up the tab once they knew where the items were, absolutely.
Months later, correct?
I don't believe so.
Well, let's keep going, okay?
Excuse me, just to complete the answer.
Sure.
The final paragraph of that May 15th letter says, quote, finally, your blatant dishonesty regrettably compels me to instruct you to act only on my written authorization, instruction or agreement.
I understand all the words. What I'm trying to find out is, 2 months after your March 26th letter, you've never told him where to deliver the items and you've never agreed to have your client pay the costs of storage, true?
Well, he asked about the cost of storage later on, and...
Can you answer my question?
Yeah, of course.
Please do.
The letters say what they say. But to make it sound like I was dodging.
I'm going to object as non-responsive to the question.
Sustained.
Well, let's go. Let's keep going and see if you ever tell him where to deliver the material, okay? We've got a letter that you sent him on May 20th, 2003, right? Is that correct?
Yes.
That's approximately 2 months since your first letter of March 26, 2003, right?
Yes.
Have you still told him where to deliver anything?
You're referring to the letter in which I say, my clients are willing to assume payment for storage of their possessions.
Yes.
And the one where I say, I ask that you provide the precise location of all such property, and the identity, address and phone number of each person with access and/or a key to any place where the property is located. Is this the letter that says, you have never responded to that more than reasonable request? And the one where I go on to say, if my clients are to, quote, assume payment on the 2 storage lockers, close quote, as you requested they do, they will obviously need that information, as well as any agreements that are to be assumed. I look forward to receiving all such information at once.
It wasn't until 2 months later that you agreed to pay the costs on behalf of your client, true?
Not 2 months after. 2 months after what?
Well, from March 26th to May 20th, you went back and forth with all this verbiage, and it wasn't till May 20th that you ever agreed to assume the costs of the storage facility, true?
No, that's false. And you know it's false, because there was no vault discussed by Mr. Geragos or even acknowledged early on. So to say it's 2 months from the date when I asked for items that were never responded to, you know that's false. So, no, it was not 2 months.
Did your client ever assume the costs of the storage locker?
I don't know whether they did or not.
You don't know till today? You don't know at all?
I understood that, well, I know that they told me that they would do so, and I transmitted that information to, it was either Geragos or Miller, sure.
Well, let's look at Miller's fax to you of June 12, 2003. Do you see that?
Yes.
It's the last document in this package, right?
Right.
Brad Miller sends you a message. Dear Mr. Dickerman. Sorry I was not able to get back to you yesterday. My office manager, Karen, let me know you called this morning. So, in fact, you're not just reducing everything to writing. You're making phone calls, aren't you?
My comment about writing was to Geragos. I have no understanding of a connection between Geragos and Miller except that Miller's doing something on his behalf.
What does that mean? What does that mean?
I didn't have a problem with Mr. Miller.
Please explain what you mean by that. He's doing something on his behalf, but you don't think he has anything to do with him.
Objection. Argumentative.
I knew nothing about.
And exceeding the scope of the direct examination.
Sustained.
Let's look further at Mr. Miller's fax to you, Mr. Dickerman, on June 12. It says, Janet's belongings were packed and loaded by Dino's Moving and Storage, 12641 Satakoy Street South, North Hollywood, California. They then placed the items in storage at their facility where they have remained since, occupying, I believe, 2 vaults. I just sent a check to Dino's for storage payment May and June. Please call John at Dino's, 818-503-3999, and make whatever arrangements are necessary to transfer the storage from myself to either you or your client. Tell Dino's they can fax whatever paperwork is necessary for me to sign, and it gives the fax number. Thank you, Brad, with a CC to Mark Geragos. You didn't know he had a connection with Geragos when you got that fax?
Objection. Argumentative and exceeding the scope of the direct.
Overruled.
Well, I don't know exactly what you mean by connection. Obviously, they had something to do with each other, yeah. But I had no problem with Miller, when you talk about putting things in writing.
Well, you got this fax of June 12, correct?
Yes.
What did you do about it on behalf of your client, Janet Arvizo?
I'm pretty sure I called my client, and told them that we had now located the items, and I believe I asked them whether they wanted to assume the cost, and I think Janet Arvizo said she did.
Did she?
I don't know. I don't know what happened after that.
No further questions.
The last letter that Mr. Geragos, that Mr. Mesereau asked you about dated June 12, 2003, that identifies Dino's moving and storage, is that the first communication you had from anybody identifying where your client's property was stored?
Yes.
Did Mr. Geragos ever tell you where the property was stored?
Never.
Did Mr. Geragos ever tell you that he had the passports that belonged to your client?
No.
Let's go back to the letter that's dated May 12, 2003. That's the one where you wanted to move on a little bit, and let's go back to the beginning of this letter.
Objection. Move to strike.
Stricken.
May 12, 2003, your letter to Mr. Geragos, do you have that in front of you?
Yes.
Read, the first two sentences end with the words, to be delivered. If you'd read those out loud, please.
Dear Mr. Geragos, I thought I had previously memorialized by letter your April 24th stunt with the movers, but I find I did not. This then will serve to confirm that on April 24th, at about 9:30 a.m., you sent purported movers to my office laden with a huge amount of furniture and possibly other items that the movers told the receptionist and building service representatives I had directed and arranged to be delivered.
Stop right there. That was the part that Mr. Geragos read to you. That Mr. Mesereau read to you. Is that correct?
Yeah, at least part of it, yeah.
Go ahead, now, and read the next sentence that you wrote.
As you know, and knew then, and as my correspondence reflected, there was no such arrangement. In fact, much to the contrary, I asked you on numerous occasions to deliver just the passports and certain other documents and a few items of Gavin Arvizo's clothing. Not only did you never deliver those items, you never even acknowledged any intention or interest in doing so.
Now, this is actually another letter I had not pointed out to you earlier where you refer to the passports again. Is that right?
That's right.
So this is the May 12th letter that refers to your client's passports?
Yes.
And previously I identified 5 different letters. That's actually May 6th, is that correct?
I haven't been counting.
Alright. Now, did you know in advance, at the time of the delivery of the contents of your client's apartment to your office building, that Mr. Geragos was going to do that?
I'm sorry, did I have any advance notice that he was going to do it?
Yes.
None.
Did he ever call you and say, we're going to just go ahead and deliver your client's property to your office?
Never.
Are you a sole practitioner?
Yes.
How large is your office?
1, sometimes 2.
Alright.
Well, and sometimes other attorneys that I associate in on cases. But as a regular matter, 1 and a secretary.
Okay. And do you have room to store a refrigerator and possessions from even a small or modest studio apartment?
I have no storage whatsoever except for some files. I keep everything off-site. I could never store anything in the building. I have no agreement with them to do so.
If you had been asked in advance to accept possession of the Arvizo family residence at your office, would you have agreed?
No,
Objection. Calls for speculation.
It doesn't call for speculation. I certainly wouldn't have. I couldn't have.
Just.
Mr. Dickerman, you can't do that, okay? Please, just answer the question.
Sorry.
The objection is overruled.
Would you have agreed to that?
Read the question back.
If you had been asked in advance to accept possession of the Arvizo family residence at your office, would you have agreed?
Absolutely not.
Alright, and nobody contacted you from Mr. Geragos's office in advance, is that correct?
That's correct.
No further questions.
Mr. Dickerman, isn't it true that at one point Mr. Geragos was so frustrated because you would not let him know where to deliver?
I'm going to object as to whether or not Mr. Geragos
Your client's property
was frustrated as exceeding the scope, and
that he had to write you a letter.
Just a moment.
He wrote you a letter threatening to auction it off if you didn't tell him where to deliver it or accept responsibility for storage, right?
Just a moment. You're going to have to start over. The question is garbled by interruption.
I'm sorry. Isn't it true, Mr. Dickerman, that at one point Mr. Geragos was so frustrated at your unwillingness to tell him where to deliver the items in storage, that he told you if you don't tell him where to deliver it, he's going to possibly let it be subject to auction by the owner of the storage facility, right?
I'll object as speculative as to whether or not he was frustrated.
Sustained.
Do you have the May 17th letter from Mr. Geragos to you?
Yes.
Let me just go through that letter with you. Dear Mr. Dickerman, thank you for your histrionic letter dated May 15, 2003. Beyond your bluster and personal attacks, please remember that you have a duty to resolve this matter in the most efficient manner possible. In that regard, please advise us as to whether your clients will accept our offer that they assume payment on the 2 storage lockers. Next paragraph. As to your request for an inventory of the property, our offer allows your clients immediate possession of all their property, period. We will waste no further time or resources of our client. You have caused us the unnecessary expense of one delivery attempt and we will not waste additional funds for the sole purpose of placating you. Lastly, please be advised, in the event your clients, 1. refuse to assume the payments on the storage lockers, or 2. fail to promptly remove the property therein, the property may ultimately be subject to auction by the storage facility. Govern yourself accordingly. Very truly yours, Mark Geragos. You wrote him back and still didn't tell him where to deliver it, right?
You're referring to the letter where I tell him that we're willing to assume payment and take delivery once he complies with the request I've been making since March 26, for almost 2 months. Is that the one?
Your position was, give me what I want, and you keep storing what I don't want at your expense.
Objection. Argumentative and asked and answered.
Sustained.
No further questions.
No further questions.
All right, you may step down. We'll take our break.